Can you hear me okay? Brad, are you there?
Yep, good.
Slides are there. All right, good morning. My name is Emma Thatcher.
I'm Brad Doring.
We are law student interns here at the Lewis and Clark Low Income Taxpayer Clinic. We were asked to do a presentation on a common taxpayer issue that we come across at the clinic and provide some guidance and insight on that topic for our community. Today, we'll be discussing the best practices and pathways for claiming children as dependents during separation and divorce. We hope we're able to provide some clarity in order to avoid pitfalls and complications in what is already a difficult time for so many families. Our main takeaways. So all parties need to be on the same page about who is claiming dependents each year. It will typically be the custodial parent who claims the dependents on their taxes, but if you decide on terms during the separation or the divorce that you will take turns claiming dependents, you should make it explicitly clear which years each party will be claiming the dependents. If the non-custodial parent is going to claim the dependent for specific years or all years, completing IRS Form 8332 during the divorce is the best practice. If there is a dispute between parties regarding who can claim the dependents for a specific year, the IRS will only recognize Form 8332. Non-custodial parents can only benefit from the child tax credit. They will not be able to claim dependents for the earned income tax credit, even with Form 8332. There are other benefits that the non-custodial parent can benefit from if they claim the dependents, but we're just going to focus on the child tax credit, the CTC, and the earned income tax credit, EITC. Roadmap. So this is what we're going to cover in today's presentation. The process of claiming dependents, separation agreements and divorce decrees, the IRS attitude towards separation agreements and divorce decrees, special rules for separated or divorced parents, and best practices to ensure IRS tax compliance. Claiming dependents for the child tax credit. So a qualifying child for the child tax credit is defined as a child must be a son, daughter, adopted child, stepchild, eligible foster child, brother, sister, half-brother, half-sister, stepbrother, stepsister, or descendant of any of them. They must be under 18 and have lived with you in the US for more than half the year. The child can't have filed a joint return, for the support element, the child could not have provided more than half of his or her own support. For the earned income tax credit, a lot of it's the same. The points that are different would be the age. So it's under 19 or 24 if it's a full-time student, or any age if the person is permanently and totally disabled. And the other big difference would be that there's no support element. So if you don't need to consider whether the dependent is providing more than half of their own support for the EITC. So those are the two main categories we're going to be focusing on for claiming dependents. Only one person may be eligible to claim the qualifying child as a dependent. As we mentioned before, it is important that each parent or person understand who's claiming the child on their tax return. Custodial parents generally claim the qualifying child as a dependent on their own return. The custodial parent is the parent with whom the child lived for the greater number of nights during the year. The other parent is the non-custodial parent, and those are the definitions that we're working with here in the tax world. There are tie-breaking rules which may apply if the child is a qualifying child of more than one person. The first step for this, for tiebreaker rules, is examining who had the child the most amount of nights. And if the amount of nights are equal, the next factor is who has the highest adjusted gross income. Non-custodial parents may be eligible to claim a qualifying child in certain situations. So special rules apply. The custodial parent can release the dependency and sign a written declaration or Form 8332 for the non-custodial parent. This applies for some tax benefits, but not all, as you can see listed here. How to use these special rules and make sure they are used correctly, meaning what works for the State Department of Revenue versus the IRS, is important, and we will discuss this later in the presentation. Please note that only the custodial parent can claim the qualifying child for the EITC credit. Non-custodial parents may be eligible to claim a qualifying child for the CTC. So the EITC is a credit that's available to employed low-income households. It's intended to boost the effective income of people who are employed. The CTC is a credit available to employed households with children. This credit is intended to help offset the costs of raising children. I'll pass it over to Brad.
All right, so when we're talking about separation agreements and divorce decrees, it's a state decree that's, binding on those parties involved. And so typically the agreement will have some kind of information in there about who gets to claim the dependents on their taxes and when. If it doesn't, it definitely should include those things because it's important to know who's going to be claiming the dependents and to have that document to fall back on in case one of the parties doesn't comply with it. However, the fact is that it's a state document, and relying solely on that state document can oftentimes leads to mistakes when you're filing your taxes. Go ahead and go to. There we go. So we're going to cover a few scenarios with you based on the information that Emma provided. So we have a couple of scenarios. In this one, there's a 50-50 custody agreement between spouse A and B. They have 3 children. One way this the separation agreement or divorce decree might have an agreement is that it might say something like spouse A will claim all dependents in even years and spouse B will claim all dependents in odd years. One of the things you have to figure out first and foremost, as Emma mentioned, is who is the custodial parent? Because the custodial parent is automatically entitled to claim those children as dependents every year. And so in order, let's say spouse A is the custodial parent, spouse B will have to have a release in the form of the 8332 or something sufficiently similar to that in order to claim the dependents in the odd years, like the agreement says. Another example of an agreement might say if spouse A is not or is current on child support, they can claim 1 dependent. Spouse B will claim 2 dependents. If spouse A is not current on child support, spouse B will claim all 3 dependents. This one, just in terms of who has custody, again, you have to know who is it, the custodial parent. There's a number of problems with this that we'll mention as we come back to these. But the big thing here for right now is just that these types of agreements aren't great. You want to be as specific as possible just so that every party knows exactly who they're claiming and when they're claiming it. And you don't want the support to be conditioned on something else. You want it to be very clear. Spouse A gets these children here, these dependents. Spouse B gets them in this situation. No exceptions. A third agreement might be spouse A and B will alternate years between claiming dependents. This one also isn't great because again, it doesn't, say who the custodial parent is. And remember, it's 50-50. And so the tiebreaker rules are going to apply where it's actually which parent or which spouse has the child or the children more often. I think before we move on, it's also important to say that most of the time, issues with the IRS pop up because both parents claim the children. And so it's really important to be very clear about who is claiming the children and when, because if both parties claim it and one person has to prove that they were actually entitled to claim it and the other person wasn't, the IRS only has 3 years to get that tax money back from the person who wasn't actually supposed to claim them. And so things have to move very quickly in order to be able to get that back. So you want to avoid any problems on the back end by being upfront about who's going to claim the children and when. One way, if you're in a 50-50 custodial agreement, you really need to be keeping a calendar of when you have the children versus when you don't, or when you have the dependents versus when you don't, because it will come down to who has the children the most in the year. And so if you're challenged on that, you need to be able to say, here's my documentation to show that I actually had them 3 more days, or whatever the case may be. Here's a second scenario. In this one, the difference is that the dependents are going to stay during the week with spouse B and with spouse A on the weekends and certain holidays. In this one, it's very clear who the custodial parent is, because spouse B is going to have them more days just based on the breakdown. And so it's not as important to keep a calendar per se, because okay, I'm the non-custodial parent or I'm the custodial parent. If I'm the non-custodial, I need to have a form to say. And again, these different agreements, they're all the same ones from the last page, but the key difference is that it's very clear who the custodial parent is. Where we run into issues is that the IRS doesn't care what your state court says, what the decree, your separation agreement, or your divorce decree says. They're a federal agency. The only thing they care about is their rules, what their rules say, because federal law trumps state law in most cases. Ultimately, this is from a case in 2013 where somebody was fighting the fact that the court order said they were allowed to claim the children, and both parties claimed it and they weren't actually entitled, and they lost the case. But it said ultimately is the Internal Revenue Code and not state courts orders that determine one's eligibility to claim a deduction for federal income tax benefits. It's really, really important, as just kind of a general take-home message, to structure your agreements and your decrees to fit into this structure of the IRS code, and include the signing of the form 8332 into your agreement. This is what the form looks like. It's a pretty straightforward form to fill out. You just want to make sure that you have it ahead of time, and that you're able to, if you're the non-custodial parent, you're able to attach it to your taxes at the time you're filing. So you don't want to have to go back and get this after the fact, because you may or may not be able to claim the dependents that way, and you may end up having a tax burden if you didn't attach the form beforehand. Specifically, this form is the best way to show that you're the non-custodial parent to claim dependents on their taxes. There are ways around using this form, but there's a very strict requirement that it has to comply with the substance of Form 8332. There's a whole bunch of requirements that have to be met in order for an order or a decree or another form that's signed to meet the standards of this form. And so your best bet is to just fill out this form, get it signed, include it in your separation agreement or your divorce decree, because there's very few cases that have actually successfully used a different document in place of this form. Also, you need to be specific in your agreements about who's actually claiming the children and when. I'll get to this when we revisit the scenarios on the next slide, but include the who, what, when, where, and why basically is what you want to include in your agreement and be as specific as possible. And again, I already talked about it, but you have to attach it to your taxes at the time that they're filed. So going back to this, we have a 50-50 custody agreement. Spouse A says they'll claim all dependents in even years, and spouse B will claim all dependents in odd years. This one, it's specific because you're claiming each spouse is claiming all dependents, so there's no split that way. In even years and in odd years. So it's easy to know, okay, we're in 2022, this is an even year. Spouse A is going to claim the children, whether they're the custodial parent or not. You still have to figure out for each year who the custodial parent is. So make sure that you write into your divorce decree or your separation agreement that the custodial parent is going to sign that form, because it could change each year depending on who has the kids for more days or the dependents for more days. So this would be a good way. You just want to add that qualifier that the custodial parent will sign the form for the non-custodial parent before taxes are due. Agreement 2, spouse A is current on child support. This is not a good way to write it because it's conditional, right? And the form 8332, you want it to be an unconditional release. The other issue with this, the way this agreement's written, is that it says they can claim one dependent. You need to be specific about which child they are going to claim so that you don't run into the issue where both spouses claim the same child and one child goes unclaimed. So instead of saying they can claim one dependent, say they will claim Billy and spouse B will claim Bobby and Susan. So again, try to be as specific as possible. You want the agreements to be unconditional. And so if you're, as a practice point, if you're negotiating these agreements, you need to negotiate it in a way that it is unconditional, so that you don't run into any issues about who's going to claim and when. Agreement 3, the issue with agreement 3 is that you don't know what years. So if you say alternating years, and the very first year you don't know who's going to claim and both parents claim, now one of them is going to end up with a tax burden that they shouldn't have had if they would have been more specific, like agreement 1. And again, it's an issue about who the custodial parents are. You want to include the custodial parent will claim or will fill out the form 8332 for the non-custodial parents. This one has the same types of issues, only it's very clear who the non-custodial parent is. And so it's not as important to say necessarily that we're going to figure it out each year, who the custodial parent is and the non-custodial, but you still want it written into the agreement that the custodial parent is going to fill out the form for the non-custodial parent. So that would be the issue with agreement 1, 2, and 3 all need those things, and 2 and 3 have the same issues from the last one, so I won't cover those again.
Thank you, Brad. So just to wrap things up, we want to reiterate these main points. Get your tax documents in order during the divorce process. If the non-custodial parent is going to claim the dependent child, complete form IRS 332. Going through a separation or divorce can often be emotionally and financially stressful, and you may not want to think about your taxes at this point, but getting this settled during this process and establishing clarity between parties is the best way to avoid any confusion or complication down the road. Be aware of who is eligible for various tax credits while making these dependency decisions during the divorce and separation process. Non-custodial parents can only benefit from the CTC. They will not be able to claim dependents for the EITC, even with Form 8332. That wraps up our presentation today. Thank you so much for joining us. If you are going through tax issues at the moment, even if it's not related to the topic of this presentation, please feel free to reach out to us here at the Lewis and Clark Low Income Tax Clinic. And thank you so much for joining us.